Hello everyone, welcome back to my channel. Thank you so much for stopping by. Before we kick off today's video, I have good news for Johnny and therefore good news for you if you are a supporter of Johnny. On the 25th of September this year, 2020, the court denied Amber's motion for sanctions and motions in limine. If you haven't watched the last few videos that I've made on this topic, you're probably really lost and you don't know what I'm talking about. So please watch them if you haven't. But this is great news for Johnny. It's one less hurdle for him to have to go through. And this is going to hit Amber's morale, whether she admits to it or not. All right, so I do have a bit to get through in today's video, so let's jump straight into it. However, if you haven't watched my previous videos on Amber's counterclaim and Johnny's response to her counterclaim, so his demur, please watch those two videos before watching this one, because this will not make any sense to you at all if you don't have the necessary context and background. Once you're done, feel free to come back here and listen to what Amber has to say. Just for the sake of completion, I'll quickly explain what the standard of review paragraph is essentially about. So in this paragraph, Amber's lawyers are submitting to the court that a demur challenges the legal sufficiency of the allegations, not the strength of the proof that has been submitted in support of these allegations. Basically, they're setting the scene for the court and using case law to support their submissions. They're informing the court that just because they don't have sufficient or strong evidence to back up their allegations, that is not the point at this stage. That's not what a demur does. A demur is an objection to the legal argument rather than the facts of the argument. So, for example, is there a cause of action? Are these legally sound arguments? And they're stating this because Johnny's demur basically attacked the counterclaim and stated that there's no basis for any of these allegations and that they absolutely have no merit. So they're trying to tell the court to disregard the lack of evidence at this stage. All right, moving on to their first argument, which is that Amber is entitled to a declaratory judgment that she is immune from civil liability as per Virginia's anti-SLAPP laws. This is why I've urged you to watch the two previous videos on this topic, because we do talk about this point in great detail, and I even explain what a declaratory judgment is. And here they're repeating essentially what they have argued in the counterclaim, which is that Amber is immune from civil liability, and she is seeking a declaration from the court that she is immune. And as we discussed, the basis for this immunity is that her statements are protected by the First Amendment and are related to matters of public concern, being domestic violence. However, we must remember, as I've stated countless times before, that this protection only extends to statements that were made without actual malice. Her legal team acknowledge this and break apart the statute into two limbs. The first limb, which is whether the statements fall under the First Amendment and are made regarding matters of public concern, is to be decided by the courts, but it's up to the jury to determine the second limb of actual malice. So if you remember from Johnny's demur, his argument was that this is an issue that is in dispute, which is whether the statements were defamatory and made with actual malice or not. And so based on that and based on the case law in Virginia, it would be improper to seek a declaratory judgment with regards to an issue that is in dispute and should be resolved at trial. This is where things start to get quite confusing to me from Amber's lawyers. Sometimes I don't know what their train of thought is. They state that this question of whether she is immune is a distinct issue and doesn't overlap with Johnny's burden of proving defamation. How can there be no overlap when the entire basis for Amber's claim of civil immunity arises entirely out of Johnny's complaint? And as if that's not confusing enough, you'll remember that her lawyers conceded earlier that it's up to the jury to decide on the second limb, which is whether actual malice exists or not. But yet further down, as you can see in this paragraph, they argue that Amber is seeking a declaratory judgment that she is not only immune from civil liability, but that her statements were not made with actual malice. But her legal team just said that that's a question for the jury to decide, which is true. It's one thing to seek a declaration of your legal rights, which is that you are immune from liability, for example. But it's entirely another to seek a declaration that you did not make these statements with actual malice. That falls under the burden of proof that must be proven by Johnny during trial. A jury needs to decide on that based on the facts and the evidence before them. They end that argument by stating that Johnny is infringing upon Amber's First Amendment rights by suing her for defamation. Except I'd like to remind everyone here that Amber is doing the exact same thing by counterclaiming and suing Johnny for defamation and defamation per se. There's a limit to freedom of expression. You can't just go around making incredibly serious false allegations against someone on a public scale and ruin their livelihood and their lives and claim that you're protected under the First Amendment. The second argument submits that Amber does have grounds for defamation and defamation per se. The first part of that argument, part A, states that Johnny's accusations of perjury, fabricating injuries, and falsifying claims of domestic abuse are not opinions, but statements of fact and are therefore actionable. And they used case law to distinguish between lying, which has been decided by courts to be a pure opinion. So if you call someone a liar, that's not a statement of fact, that's just a matter of your opinion. But accusing someone of perjury, they argue, is an accusation of criminal conduct and therefore amounts to defamation per se. They further argue that Johnny's allegations can be disproved by evidence from Amber and therefore should proceed to trial. In argument B, they claim that Johnny and Adam Waldman's accusations are not privileged. Now, if you'll remember from Johnny's demur, they claimed privilege over the statements that were made in connection to Johnny's lawsuit. So anything that Adam Waldman and Johnny publicly said after he filed the complaint is protected by absolute privilege, which includes things that they have stated in their case. So for example, that she is orchestrating a hoax and that she is a liar. That all falls under absolute privilege because all of these statements have been made in direct connection to these judicial proceedings. The defense even concedes that this immunity extends to beyond the courtroom to communications that are material, relevant, or pertinent to judicial proceedings. So you don't have to be in the courtroom when you make these statements. You can make them on Twitter, on a YouTube video, and to media outlets. Now, her lawyers latch on to qualified privilege, not really absolute privilege, which they also refer to as judicial immunity. The distinction essentially is that absolute privilege is an absolute defense, regardless of whether any of the statements were made with malice. Qualified privilege, which as they say here, attaches to communications made between people who have an interest in or a duty in the subject, can be lost if malice is proven. So they're saying that Adam's statements of her perpetuating a hoax, etc., are lost because they fall under qualified privilege, since he is a lawyer that has a duty or an interest in the topic. They state that that privilege was lost because Adam's words and Johnny's words were made with malice. So they're assuming, essentially, that Johnny is claiming qualified privilege because he failed to specifically state the word absolute privilege or judicial immunity. I can't remember off the top of my head if they did use the word absolute. I will put it up on the screen right now if they did. But essentially, absolute privilege kicks in as a defense as soon as it is clear that all of the statements made are in connection to or are relevant or pertinent to judicial proceedings, which is very easily established in this case. Everything Johnny and Adam have been saying, especially since this complaint was filed, has been in direct connection to this case. They further argue that statements made in the GQ magazine interview that was published in November 2018 are not covered by privilege as they were made before the op-ed was published and as such before this complaint was even filed. While this argument is valid, when you look at it in isolation, it entirely ignores the statute of limitations for bringing defamation actions, which is 1 year. And we will talk about this later in the video as it's a major component of their argument. They also bring up fair report privilege, but I don't believe that Johnny's team are claiming fair report privilege. That defense is usually utilized by journalists, by the way, but I do believe that the privilege being relied on here is absolute privilege and maybe even qualified privilege. Now, a major component of my arguments on behalf of Johnny when addressing Amber's counterclaim was that his statements in the GQ magazine interview were in self-defense. And later on, when Johnny filed his demur, those exact arguments were made by his lawyers as well, because we all have a right to defend ourselves, especially against incredibly serious allegations. So Amber's argument to that is that this claim of self-defense cannot apply because the op-ed was not an attack and was published after the GQ interview. But this argument of self-defense that Johnny is relying on is not directly tied or in relation to the op-ed. It's in relation to the allegations that she has been voicing over and over again, almost relentlessly, since 2016. He was asked about these allegations in an interview, and he responded to the question. They go on to claim that if self-defense applies to anyone, it would be to Amber, not Johnny. So anything defamatory that Johnny is relying on, Amber wants to claim that she made those statements in self-defense, which is ludicrous because she spoke out first. She started this and Johnny kept quiet until, again, as I said, he couldn't take it anymore and she crossed the line. Finally, with regards to this second argument, they state that Amber's statements made in connection to the DVRO, so the restraining order proceedings, are protected by absolute privilege, which is correct. They were made in connection to judicial proceedings and therefore anything she said cannot be used by Johnny as proof of defamation. But he is suing her for the op-ed. The DVRO proceedings took place in 2016. Did he sue her for anything back then? No. It was only after December 2018, after the op-ed was published, that Johnny decided to sue for defamation. Their third argument is a repetition of an argument made in Amber's counterclaim, which is that Johnny violated the Virginia Computer Crimes Act. This is once again an area that we have covered extensively in that video and also to some extent in the video about Johnny's demur. So I won't be repeating my arguments here. I even presented evidence that entirely rebuts her allegations in that video. The new aspect that was never brought up before is Johnny's text to, I think it was Paul Bettany, back in 2013. And this is the text that they are referring to. We're going to very thoroughly destroy her argument once again. As you can see, the first element that must be satisfied, meaning the first hurdle that the defense must overcome, it's not optional, is the mens rea, or mental element of intention. So it states that if any person with the intent to coerce, intimidate, or harass. But notice here how the defense conveniently ignored that first hurdle and went straight to the actus rea, which is the action part of the statute. And if you think that they did this unintentionally, you would be wrong, because this is where their argument entirely collapses. Johnny sent this text to Paul Bettany, or whoever it was, but it was a close friend, in a private capacity. Were his words obscene, lewd, lascivious, inappropriate? Yes. But was the intention of this text to intimidate, coerce, or harass Amber? No. He was exercising his rights under the First Amendment to express himself and how he felt about her in a personal moment with a close friend. Because of these reasons, the mens rea, or mental element of this crime, has not been satisfied. Can you imagine a world where we're all breaching the Computer Crimes Act in our respective jurisdictions when we vent to a friend in a personal capacity and call people names that we shouldn't be calling them? I mean, really? Their fourth argument relates to the statute of limitations. So, as we said before, defamation claims have a 1-year statute of limitation, which means that a plaintiff has 1 year from the date of publication to bring a defamation claim. And as we discussed in the video regarding Johnny's demur, and also in this pinned comment that I made under the counterclaims video, this time limit has run out, especially with regards to any statements made before July 2019. Now, you'll see from my pinned comment that there is an exception that I mentioned, which is that if the counterclaim arises out of the same transaction that led to the plaintiff's complaint. and that is based on this relevant section of the Virginia Code. So that reads, if the subject matter of the counterclaim or cross-claim arises out of the same transaction or occurrence upon which the plaintiff's claim is based, the statute of limitations shall be tolled by the commencement of the plaintiff's action. So essentially here they're claiming that all of Amber's allegations in her counterclaim arise out of the same transaction because all of these statements were made in connection to the DVRO proceedings that took place in 2016, which is the very same testimony that Johnny claims was revived in Amber's op-ed. So essentially they're saying that even though Johnny is suing Amber for the op-ed, all of her statements in the op-ed are based on what happened in 2016 with the DVRO proceedings, and anything Johnny said with regards to Amber lying during those proceedings and perpetuating a hoax are in connection to that same proceeding and therefore arise out of the same transaction. They then go on to rely on case law, and the main gist of their argument is that this interpretation of arising out of the same transaction is a flexible one. It's enough that they are all logically related events, meaning it doesn't literally have to be the exact same transaction. So in this case, it doesn't have to be the op-ed. And they quote further case law where courts held that even the facts and the evidence relied upon in the counterclaim need not be the same as those relied upon in the initial complaint that was filed by the plaintiff. So they're saying essentially that Johnny and Amber, even though they did it through different mediums or different platforms or different articles and different dates, were talking about the same thing. I'm not too familiar with Virginia case law, so I don't know of any opposing arguments, and I am gonna have to wait for Johnny's side to bring up their own case law to oppose this, because if there's one thing I can tell you, it's that lawyers will cherry pick cases in order to support their argument. There is a vast amount of case law out there. A lot of them have opposing decisions, so they contradict one another. And what lawyers do is they pick the ones that support their argument, and it's up to the other side to find case law that opposes the other side's argument and supports their own argument. I still think that there is still a very strong possibility to argue that the GQ magazine article and the op-ed are two entirely separate transactions, and despite the fact that they were maybe talking about the same thing, which is their abusive relationship, that's not what Johnny's claim is arising out of. So the GQ article has nothing to do with Johnny's complaint. Their final argument states that Johnny is not covered by the anti-SLAPP statute, which Johnny relied on in his demur. So they're stating that his statements were not in relation to an issue of public concern and were highly personal in nature. They further go on to state that if the court was to find that they were indeed in relation to matters of public concern, then the issue of whether they were made with actual malice is an issue for the jury to decide, which is exactly my main issue with Amber's insistence of getting a declaratory judgment that she is immune from civil liability. You still have that important limb of actual malice that must be determined by a jury. So she expects the court to declare that her statements were not made by actual malice, but when it comes to Johnny, a jury must decide on that. So what we have here is yet another flagrant display of Amber's beliefs that one set of rules apply to her and an entirely separate set of rules apply to the rest of the world. Domestic abuse, regardless of the gender of the victim and the perpetrator, is a topic of public concern. It doesn't cease to be a public concern issue when a man is the victim, because again, that's clearly what Amber is trying to insinuate here. When she talks about it, it's a Me Too movement issue. It's a global issue. Women all around the world are abused by their husbands and their partners. But when a man says the same thing, it's suddenly personal to him, because it doesn't happen anywhere else in the world. Johnny's the only man, apparently, who has ever been allegedly abused by a woman. Starting this channel and talking about this issue has only shown me how widespread this problem is, because men from all walks of life have started to reach out to me and have been doing so for a number of months now in private to tell me how Johnny encouraged them to speak out. He made them feel like it's okay to talk about it. That's it for this video. I hope you found it informative and helpful. As always, don't forget to let me know what your thoughts are in the comments below. Thank you so much for watching. Stay safe, and I'll catch you in a future video.